In this video, we will be discussing about Introduction of RPC Book 1. Introduction.
What is criminal law?
It is a branch of public substantive law which defines crimes, treats of their nature, and provides for their punishment. It is a public law because it deals with the relationship of the individual with the state.
Important terms. Crime, the generic term used to refer to a wrongdoing punished under either the RPC or under special laws. Ortega,
an act committed or omitted in violation of a public law forbidding or commanding it. Felony, a crime punished under RPC. Offense, a crime punished under special laws. Misdemeanor, minor infraction of law.
For example,
Felony.
Offense.
misdemeanor.
sources of criminal law.
1. The Revised Penal Code Act
3815. 2. Special penal laws. 3. Penal presidential decrees issued during martial law.
4.
Batasang Pambasa. Legal maxims. There's no crime when there's no law that defines and punishes it.
The act cannot be criminal unless the mind is criminal.
An act done by me against my will isn't my act. He who is the cause of the causadis, the cause of the evil caused.
Next is the characteristics of criminal law.
Number 1.
General.
It is binding on all person who live or sojourn in the Philippine territory.
It means that all people, regardless of nationality, gender, or other personal circumstances. To simply put, it refers to people. However, there are exemptions such as treaty stipulations under RP's Visiting Forces Agreement, which was signed in February 10, 1998. And the warship rule states that a warship of another country, even though docked in the Philippines, is considered as an extension of the territory of their respective country.
Same rule applies to foreign embassies in the Philippines. Philippine warship and embassies abroad are extraterritorial. Lastly is the principles of public international law.
The following persons are exempted. Scam A.
Sovereigns and head of state.
Charges de affaires. Ambassadors.
Ministers plenipotentiary. Ministers resident. The second characteristics of criminal law is the territoriality of territorial.
The general rule states that penal laws of the Philippines have force and effect only within its territory. This characteristic simply refers to place.
If you commit a crime in the Philippines, you are subject to the Philippine laws and triable in the Philippines.
However, there are also exemptions to this, where you can be prosecuted in the Philippines even though you committed the crime abroad. It is called extraterritoriality. It refers to the application of the revised penal code outside the Philippine territory. Extraterritorial crimes, enforceable even outside Philippine territory against those who
A.
should commit an offense while on Philippine ship or airship.
For more information and better understanding, please look at the table and take note.
French rule vs English rule.
Next is, should forge or counterfeit any coin or currency notes of the Philippines or obligations and securities issued by the government. Another is should introduce into the country the mentioned obligation and securities. Fourth is while being public officers or employees should commit an offense in the exercise of their functions.
Here are the following examples.
Lastly, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2.
The third characteristics of criminal law is the prospectivity or prospective. It states that penal laws cannot make an act punishable in a manner in which it was not punishable when committed. So basically, it refers to time. However, the law may be applied retroactively when the new law is favorable to the accused. Always remember that there shall no ex post facto law or bill of attainder shall be enacted. When we talk about ex post facto law, always remember our maxim. There is no crime when there is no law that defines and punishes it.
Bill of attainder, on the other hand, is that act that inflicts punishment without trial.
To summarize the three characteristics of criminal law: general, territorial, and lastly, prospective.
That is all for the introduction of Revised Penal Codebook 1.
I hope you are taking notes and learned a lot. Next chapter, we will discuss about preliminary titles. This is your Criminology Review partner.
Until next time.